Good evening, good afternoon, good morning, wherever you are joining us from. For those of you joining us for the first time, welcome to the Essex Public International Law Lecture Series. And for those of you who have been joining us before, welcome back. My name is Dr. Megan Wong. I'm a lecturer at the School of Law at the University of Essex and the founding director of the LLM in International Law degree. And together with Dr. Emily Jones, we are the co-founders and co-conveners of the Essex Public International Law Lecture Series. I'm delighted to be your host for today's event with our speaker, Professor Glider Hernandez, which will be chaired by Dr. Emily Jones, and I will defer to Dr. Jones, our chair, to introduce our excellent speaker today. In my role of host, I wanted to speak a little bit more about the Essex Public International Law Lecture Series. Our lecture series was opened this year by Professor Pierre-Marie Dupuy on the universality of public international law in the year 2021 and the years to come. And if you would like to watch that, that's available on our channel, the recording. So let me tell you a bit about the Essex Public International Law Lecture Series. This series is built upon two important intellectual traditions of public international law, formalism and international legal practice, and international legal theory, including post-colonial and feminist perspectives. Now, the idea for the series stems very much first and foremost from our friendship, and is inspired from our respect for each other's scholarship and research. Dr. Jones and I are both generalist public international lawyers with several specialist interests, including our mutual interests in international law of the sea, international environmental law, and the law on the use of force, but we write from different approaches. I'm a formalist, and Dr. Jones is a critical legal scholar, and we hope that this series brings together something for everyone. Today, we're very pleased to have Professor Hernandez to deliver a lecture entitled The Determinability of International Law, Situating Interpretative Authority. Let me now introduce our excellent chair for today's event. Dr. Emily Jones is a senior lecturer in law at the University of Essex. She's a generalist public international lawyer specializing in gender and international law, science and technology and international law, and in international environmental law. Dr. Jones recently published a co-authored book with Bloomsbury entitled The Law of War and Peace, A Gender Analysis, Volume 1, and her monograph, Feminist Theory in International Law, Posthuman Perspectives, is forthcoming with Routledge's Glasshouse series, so something that we can all look forward to. And now over to my formidable friend, colleague, co-convener, and co-founder, Dr. Emily Jones, to commence this event.
Thank you so much, Dr. Wong. It's a pleasure, as always, to be co-convening this Essex Public International Law Lecture with you. I am very proud, everyone, to be your chair for this evening for Professor Glider Hernandez's lecture entitled The Determinability of International Law, Situating Interpretive Authority. So Professor Hernandez, as I'm sure you all know, is a fantastic example of a scholar whose work really bridges the theory and formalism divide in international law. And I know that today's lecture will also indeed bridge both sides of that academic debate, focusing, of course, in particular on the role international lawyers, in fact, play in terms of international law. So he is, of course, a very fitting speaker for the series, and we're both very, very proud to have him here with us today. But to introduce our speaker properly, Professor Glider Hernandez is Professor of Public International Law at the University of Louvain and Open Universitat. Previously, he was a reader in Public International Law at Durham Law School and founding Deputy Director of the Durham Global Policy Institute. Professor Hernandez has held visiting professorships and research fellowships at multiple institutions, so Harvard Law School as a Fulbright Scholar, Durham Institute of Advanced Study, Université Paris-Nanterre, the University of Amsterdam, McGill University, and the TMC ASA Institute. And in 2022, he will be Director of Studies in the English strand at the Hague Academy of International Law. So congratulations on that, Professor. Prior to his academic career, Professor Hernandez served as a law clerk at the International Court of Justice, where he clerked for the former president Peter Tonka and Judge Bruno Sima. And he was also called to the Barreau de Quebec and practiced as a barrister at Fasken Maintenot LLP. Professor Hernandez took a DPhil from Wadham College, Oxford, and read for LLM degrees at Leiden University and BCL, and LLB degrees at McGill University. And is, of course, the author of the International Court of Justice and the Judicial Function, which came out with Oxford University Press in 2014. And of course, International Law, Oxford University Press. And there's a forthcoming new edition next year. And it's, of course, a book that we use on our courses at Essex. So that's really wonderful for our students who are in the audience. So Professor Hernandez today will be speaking to the title, as I mentioned, of The Determinability of International Law, Situating Interpretative Authority. And before I hand over to him, just a quick housekeeping note. If you do want to ask a question, there is a Q&A button at the bottom of your screen. It's got kind of like 2 speech bubbles. So you can click that and you can ask your question. If you do want to remain anonymous, then please just use the tab to click anonymous, ask a question anonymously. If you don't do that, then I may possibly read out your name. So make sure you do that if you don't want me to. And without further ado, Professor Hernandez, the floor is now yours. Thank you for joining us.
Jones, thank you for such a lovely and generous introduction. Dr. Wong, thank you for inviting me. Thank you to both of you also for this degree of formality, which is rather elegant, I think, especially with these online events that have become increasingly informal. It's an absolute pleasure to be here virtually, to have the opportunity to speak on scholarship. I feel these days we spend most of our time online discussing anything but scholarship. So the opportunity to test out some ideas that have been germinating for some time is a wonderful one. And I was very flattered by the invitation, and I must say the oscillation between formalism and more critical work, I thought rather suited the theme of what I want to speak about tonight, which is an exercise in a very personal brand of analytical jurisprudence and an attempt to understand authority within the international legal system and the role that indeterminacy plays within it. So I will speak for about 35 minutes. I'll try to lay out the argument for you. At the same time, it's based on a rather extensive piece that will be published shortly in the Netherlands International Law Review. The Netherlands Yearbook of International Law. Sorry, I'm not keeping track properly. So I'll try to sketch out the core of the argument in order to elicit discussion. Of course, please be robust in any feedback. The interaction in itself is extremely valuable. I'm not presenting with PowerPoint because I've taken a principled view that whenever possible, we should try to engage the way we used to back in the good old days. Anyhow, so my argument proceeds as follows. The international legal system, to my mind, remains characterized by a degree of indeterminacy. And whatever the proliferation of institutions that claim some sort of interpretative authority, which, in my view, if informal, is nevertheless substantively law creative, there is a lack of systematicity, both in mainstream doctrine and in legal theory, in addressing how international actors can claim and exercise that authority. But as with nature, law abhors a vacuum, and practices and strategies develop in practice so as to cure indeterminacies that might arise from time to time. Though the claim would remain that such organs, agents, or officials apply and interpret the law only within specific factual contexts, in particular in relation to the contours of a specific dispute. The contours of legal rules, as we all know, expand, contract, and evolve. So in short, my argument rests on the premise that any purported gaps in international law are quickly accompanied by claims by international actors to be the empowered, legitimate, or authoritative actor capable of filling them. Authority claims, thus, are in a mutually productive relationship with the antecedent existence of indeterminacy. And so what does that mean exactly? What does it mean to have indeterminacy as a necessary part or as a co-constitutive part to the claim of authoritative actors to fill it? To my mind, it is not incoherence. It is not to suggest that indeterminacy is always a part of law, but rather that within much legal theory, there's a claim that needs to be deconstructed, that mechanisms or institutions of determinability become identified, endowed, or bestowed with the authority to fill those gaps, usually through an interpretative process. whether domestic or international. A legal system invariably allows or tolerates such actors to exercise that discretion. I suggest that this demonstrates a self-empowering dimension, an almost autopoetic dimension in Lumanian terms, by the legal system itself, and that a legal system, in fact, articulates and necessitates a certain systemic function, which later on I'll suggest is in favor of coherence and order. Now, of course, any such thing requires us to think about what we mean by a legal system. And here I intend to go beyond the notion that the law constitutes a formal body of rules that itself stands as a legal system. Perhaps, but I think inherent in any discussion about a body of legal rules, about legal systems as rules, remains the identification of actors who engage with these rules, in particular through legislative, adjudicative, and enforcement exercises. The legal system, to my mind, thus has a social dimension, and thus legal authority is not merely authority within a legal order that bestows on certain officials the ability to develop the law, but rather in a second sense. So yes, there is a discursive conception of authority that is justified as a sort of middle ground between coercive force or purely persuasive authority, the ability to influence only through merits. I think we must understand authority in a self-standing part, the way Herbert Hart would have called it, content-independent authority, the idea that certain actors or officials command a normative expectation beyond power or persuasion. Joseph Raz points us, moreover, to another sense of authority, which is a force to justify the existence of law and legal rules themselves, and the normative force of any norms produced within that system. To my mind, these exist together, and they open up the space for central discussion, the focus on certain officials as law-applying authorities within the legal system. In a domestic system, it's relatively easy to identify, but within our international legal system, being decentralized both conceptually and in practice, I think it is important to adopt a customized account, one that takes into account the realities of international law. To my mind, in many respects, we're adopting a functional account. This is for two reasons: to identify the mechanism of closure, and to advance the claim that the social practices of norm-applying actors are themselves constitutive of the international legal system itself. In the last part of my presentation, I want to advance, I think actually this one I may just pass along very briefly, but what I want to do very quickly is just to say that there is insufficient theorizing about such legal officials. And I think broadening our understanding of authoritative legal actors is useful in understanding the nature of international law more generally. And the claim I'll advance at the end is that in studying this, I think the constitution and the construction of international law and the bestowal of authority on given officials rests in part on sociological practices. In fact, on the technical competence or proficiency of law-applying authorities, who, and here I rely, of course, on the classic work of Owen Fiss, their authority rests on common discourse rules that define us as an epistemic, professional, or interpretative community, a community of elites with a shared vocabulary, a shared technical proficiency, through which we recognize, how can I put it, recognize, reject, and validate certain forms of legal argument. To my mind, those interpretative practices reaffirm the membership of actors making claims to interpret the law correctly, as it were, as part of that community. And with them, such actors internalize a commitment to preserve the coherence and existence of international law. Marti Koskiniemi put it better than I. International law's objective is always international law itself. So first, indeterminacy. There have always been those who maintain that international law remains determinate, with rules of interpretation primarily hermeneutic or only cognitive. I think this claim is premised on the immanent rationality or the possibility of objectivity in the law. But to concede indeterminacy, given the roots of the concept in linguistic constructions, requires us to accept or presume the partially constitutive character of interpretative acts. So the question arises, if law is indeterminate because its commands are conveyed through a language which is itself indeterminate, international lawyers face the question of what they ought to do with that determinacy. And so as such, most of mainstream 20th century legal scholarship considered indeterminacy as a problem to be addressed. From the Advisory Committee of Jurists concocting or devising the terms that became the general principles recognized by civilized nations in Article 38, or more recent techniques like effectiveness or systemic integration, all aim to cure potential gaps. Put more simply, indeterminacy is the problem. Law creates mechanisms of determinability. And one sees this both in international legal theory, but of course its roots are in domestic legal theory. And I want to point to two canonical examples, the work of Hans Kelsen and that of Herbert Hart. Hans Kelsen first. Kelsen, of course, is known for his pure theory of law and the claim that every legal rule could trace its validity back to another legal rule ad infinitum until the Grundnorm. But he was perfectly happy with conceding intentional indefiniteness of certain law applying acts, and even unintended indefiniteness inherent in the linguistic formulation of legal rules. His critique of classical legal positivism was that an act of interpretation was only that of understanding. He always situated it, in fact, as an act of will or cognition. It was a choice, but it was a bounded choice. For Kelsen, the legal system constitutes a frame which confines, restrains, and delimits the available choice of norms. This legal reasoning is almost, I wouldn't say it's identical, but it's very, very similar to that of Herbert Hart, his common law counterpart, who foresaw that within a legal system, even cases that he would call the penumbra, hard cases, even if they proved from time to time a fundamental incompleteness in law, his solution was nevertheless that discretion exercised by legal officials, now in his mind, the quintessential legal official being a judge, would be the mechanism through which the law itself, the legal system, would prescribe rules that are sufficiently determinate to thus continue closing the system and continue forestalling those gaps that would arise. Of course, Ronald Dworkin, building his entire theory on the hard cases claim, rejected the very idea that law could be incomplete, instead choosing a view that rather the law is not so much incomplete, the legal system renders the law determinable through mechanisms of integrity, law's empire. Officials within those legal systems would make decisions authoritatively, exercising a bounded or weak form of discretion through the application of principles, systemic values which underlie all legal rules. Now, of course, they're all different in their emphasis, and they stand for different forms of legal positivism or interpretivism, and Dworkin late in life pinned down as a certain form of natural lawyer. But they all shared the view that legal interpretation is the fundamental act which cognizes the possibilities available within the frame of the system. There might be ambiguity, but the frame will provide a structural backdrop through which meaning can be stabilized. None of these theorists had an issue with the indeterminacy of law from time to time. Instead, their emphasis was through endowing law-applying authorities to choose, to determine, and to close the gaps. Now, of course, Koskiniemi exploded all of this in the publication of From Apology to Utopia. The thrust of his argument, of course, is to refute the claim to determinacy and the embodiment which comes in it of a certain universality, or at least the embodiment of universal values. Instead, in sum, for those of you who haven't read From Apology to Utopia, which probably not that many these days, but his argument is that international law is characterized by the oscillation between ascending and descending arguments from justice and consent respectively, but neither of which captures the necessary objectivity to delineate law fully from other social processes. But it is in that oscillation, in that form of argument, that the grammar and that the structure of international law is defined, which channels legal argumentation on both sides. It confines the form of argument, though, only, and not its substance. The claim being, in essence, that so long as international legal argument is justified through what is professionally accepted, just about any course of action can be justified through the language of international law. And although we might disagree and consider it right or wrong, the form of legal argument becomes legitimate. So it's on that basis that Koskiniemi articulated this rejection of determinability. Of course, his critique goes further. It raises claims as to ontological indeterminacy or radical indeterminacy, which many mainstream scholars have found difficult to follow. But what is relevant here, and what I want to focus on, is his semantic critique of the hermeneutic approach. In simpler language, his linguistic analysis to reject the idea that interpreters interpret and interpretation constitutes law in the circle. From Apology to Utopia, in this sense, is an attack on the recourse to systemic principles or values that guide international actors towards a desirable, or at least internally coherent outcome. To him, the discretion exercised by systemic officials, which Kelsen, then Hart, and then seized upon by Dworkin, to him they're derided as a manifestation of structural bias masquerading as stability. In his words, in any institutional context, there is always a particular constellation of forces that relies on some shared understanding on how the rules and institutions should be applied. Now, I read Koskieniemi not to suggest the impossibility of law's coherence, but rather to situate it as a political project. It is to suggest that coherence can only be achieved through the interaction of different actors who privilege certain interests, in particular, coherence itself. Emmanuel Joannet's critique in this respect, I think, is very relevant, engaging with the act of judging and as inextricably tied to power. It reflects this narrative. Now, forgive me, I'm going to read in French for just a moment. I forgot to translate this before, but in essence, le juge international joue un rôle non négligeable, voire décisif, dans l'affirmation de ses hiérarchies normatives et le souci de participer au maintien du système dans lequel il s'insère, s'ajoute une exigence de cohérence formelle de son propre discours judiciaire. Having read it, I can now translate it. The international judge plays a non-negligible, in fact decisive role in the affirmation of normative hierarchy and in the desire to conserve and uphold the system in which the judge plays a role, and that becomes a formal condition of coherence for their own judicial discourse. In other words, the critique of determinability opens up space through international law's indeterminacy for specific actors to construct and to maintain their authority for the interpretation and thus development of international law, moving authority away from words and linguistic terms and reorientating it towards socially cognizable behavior. The question is not whether law is indeterminate. The question is rather to whom members of the community turn who claim and who are recognized as holding authority over legal norms with sufficient legitimacy to be accepted by those actors. So what do I mean then by authority? How is it distinguished from legitimacy? And I think here there's an important point. Now, I do not, in this particular paper, I want to focus on the notion not so much of legal authority or sociological authority or even de facto authority. Karen Alter has written a really interesting piece on de facto authority. Rather, I want to focus on the concept of interpretative authority and why it is relevant. Of course, it's not the same thing as authoritative interpretation, which in its most classic sense, I think we all understand as the consent given by parties to delegate the authority to interpret a named institution or text. This is, of course, how we would have understood it in the Vienna Conference on the Law of Treaties, the distinction between Article 31 and Article 32, good, classic, positivist stuff, of course. Instead, I think we need to see interpretative authority here more closely aligned to the social practices of an actor, the actor's capacity to find recognition in its discursive practices for interpretative claims. Ingo Venskes called these content-laden reference points that an authoritative actor can set, which then in turn shape future discourse on a given matter. The classic example for us is, of course, when the ICJ makes a pronouncement, for example, in respect to the law on jurisdictional immunities when faced with a claim of a breach of jus cogens, or the exact point in time when customary international law and self-determination became crystallized. And those of you who've been reading your judgments know very much that I'm speaking about jurisdictional immunities or separation of the Chagos Archipelago. The point, though, is not about the substance of the determinations, but is about the actor or institution and the fact that by making such statements, they are not exercising content-dependent authority, which rests on the merits of the claim, but content-independent authority based on the prestige or authority of the actor who is making them. The social practices to which I refer are those of recognition that legitimate that claim to content-independent, self-standing authority. Joseph Raz calls this form of authority basically a species of power, but fundamentally distinct, in that rather than being exercised coercively against the will of another actor, rather it is an authority that induces the consent of the addressee differently than traditional conceptions. So to submit to authority, if we are a law professor, a legal practitioner, a legal advisor to a state, is to be induced consensually to substitute our will for that with the actor vested with authority. And in that respect, curiously, it's actually an anti-rational point. To be subjected to authority, as Raz says, is incompatible with reason. Reason requires that we act on the balance of reasons of which one is aware. The nature of authority requires submission, even when one thinks that the actor making an authoritative claim is wrong. Understood thus, authority compels obedience in the absence of agreement on substance and is accepted as legitimate. And thus there is where I think the distinction is. So if authority is intended to function as a reason which is independent of the merits or nature of the character of what is being decided, then its essence is content independence. Its essence is the identity of the person or institution making that decision. Authority trumps our own rationality and requires us to submit to the claim of the more influential, the more expert, the more legitimate actor to make a pronouncement. In very simple terms, Glider, the law professor, has a distinctly lower level of authority than the pronouncement by the European Court of Human Rights, the Iran-US Claims Tribunal, or the Assembly of States Parties amending the elements of crimes of the Rome Statute. And it is precisely because certain actors, through their procedures, through the form of their pronouncements, induce obedience with their directives, that the community accepts a content-independent claim rather than substantive reasons on a case-by-case basis. Authority in this sense requires subjects actually to do or to decide something other than what we have done or what we have decided. And in essence, that is in the nature of law itself. We obey law because it is law. So the connection between the authority of certain actors and the power of law, I think, becomes quite intimate. And it dispenses with the idea that we must convince and persuade on the merits of what the law says, but rather we are limited to, how can I put it? We are limited to commanding that the law be obeyed by virtue of it being law and by virtue of it being applied or interpreted by a certain actor. This claim rests, I think, and this is where I'll be turning to, it rests on where authority is located in a legal system itself. It reflects the law-applying authority's duty to apply the law as it is, and the expectation that if it so does, then the legal order will be upheld, will be enhanced by the correct discharge of its duties. In this respect, I think, there's a degree of legitimacy which stands apart from the concept of authority but helps to feed into it. And here I'll just borrow very freely from Thomas Frank's work on legitimacy within international law. But in his definition, which I think is serviceable here, legitimacy is a property of a rule or rulemaking institution, crucially, which itself exerts a pull towards compliance because those addressed believe that the rule or institution has come into being or operates in accordance with generally accepted principles. So you see that principle of recognition coming again. In this sense, I think this allows me to turn to where the source of authority is within international law, especially with respect to institutions that put forward a claim. Is it just in constitutive instruments? Is it just a formal directive endowing or bestowing certain actors or institutions with law-applying capacity? I don't think so. I think it is also a property of legal systems themselves. And it goes further, I think, than just endowing certain institutions through law, but also through social practices. But before turning to that, I want to turn to the centrality of law interpretative officials per se, as central to the concept of a legal system, at least the way we understand it through mainstream positivist accounts of what a legal system constitutes. And in that sense, I'll rely on the language that Herbert Hart would call of law-applying officials, which he argued are necessary and sufficient conditions for the existence of a legal system. This is in part because to have legal officials requires not only that these legal officials be empowered either to make the law or to interpret the law or to enforce the law, but rather because the very foundation of the law, in his case, it was called the rule of recognition. So the rule through which law and the capacity to make law are recognized by the members of the political community the legal order represents. Basically, for Hart, rules of recognition must be accepted in the first instance as common public standards of official behavior by legal officials. The presence of such rules is presumed, and the acceptance by legal officials is also presumed, because it is taken to be system constituted. In a way, this is what we would call his social thesis, which reaffirms, creates the contours of what is law and differentiates it from what is not law. Joseph Raz takes that argument even further. He claims very, very explicitly, norm-applying institutions are a necessary component for law to be understood as a legal system. The existence of these institutions is a characteristic of modern legal systems, and although it might not be a necessary feature, the existence of some type of norm-applying institution is. Now, within international law, of course, our formal institutional structures, our formal concept of law doesn't explicitly endow certain actors with this role. And of course, the role of judges has been studied through any number of lenses, through sociological lenses, institutionalist lenses, projections, through analogy from domestic law. But nevertheless, one argument or one potential that has consciously and consistently recurred has been about the potential lawmaking and law interpretative role of judges. We can trace it from the debates from the advisory committee that drafted the PCIJ statute, the redrafting of the PCIJ statute to the drafting of the ICJ, the many debates in relation to the proliferation of courts and tribunals in the 1990s. And questions have arisen in all manner of specialized regimes, ranging from the WTO appellate body and the deadlock there, the claim of autonomy of the EU legal order, which claims to have been the only successful legal order that has fragmented from international law, though I know many of you might beg to differ. But the point is, why the practice of these institutions or actors has come to be regarded as authoritative in the absence of any formal claim to do so. Now, again, there is no systematic official designation of international legal officials. To claim that the ICJ is some sort of general court of international law that transcends its role as the principal judicial organ of the UN, an international organization, goes a little bit too far. It was on that basis, in fact, that Hart, in his infamous chapter on international law, rejected the idea that international law could be considered a legal system because it didn't have this formal endowment, and he differentiated between the United Nations and the ICJ. But that said, is this how international law works in practice? Is it the way international lawyers work in practice, the way legal advisors to states, legal representatives of states arguing in international courts, activists, civil society, the third sector, etc.? No, it isn't. Not at all. There is a social practice which defines and binds us as international lawyers, which has impelled the creation of international courts and tribunals. To deny that these courts even fulfill the modest function of whether a rule has been breached or whether there are legal effects arising from that breach would also be to deny their potential authority. And I think even irrespective of the lack of formal endowment, and this is a concept I keep developing and I keep working on, and I'm never quite satisfied with how I articulate it, our international courts fulfill the notion required by Hart's legal theory that you must have some sort of legal official who internalizes the general rules of the international system, and even if not centralized, I believe that this role is applied in particular by courts, but also by other institutions, perhaps including the International Law Commission, and certainly the legal services of states, which are in a daily process of engagement with international law. Now, I don't want to go into a fully articulated concept here. I think that goes a bit far, but I do think that at least a functionalist account allows us to at least oscillate between the formal and the critical themes of this particular lecture series, and get rid of the concern if we don't name them. Indeed, I think if we take a social practice thesis, and here I rely a little bit on the work of Jean d'Apremont in this respect, in his engagement with Hart, I think there is something to be said about the social practices of legal officials operating within our legal system and continually validating the system. Why? Because a sufficient number of legal subjects, centrally states, but also other important actors, comply with these behaviors. And also, there exists a community of legal officials who, between them, perceive the law as having sufficient authority in setting out acceptable standards of what is law, what is not law, what is lawful, what is not lawful. In that comes the power to cure indeterminacy, through the convergence of the different behaviors and agreements of these various authorities. And how do they do that? They work not only to identify the legal existence of norms and of rules, but also to continually identify, re-identify, reinforce who gets to interpret them. This is not to say that they become a source of law, but rather it is to say that as officials of the system, judges, law-applying authorities, and even practicing elite international lawyers share a meaningful normative language, which through teaching, through practice, and through its adoption and internalization by states and international organizations, they imbue the law with normative character. It constitutes and it reaffirms the legitimacy of the law. Now, I see that I'm running a little bit out of time, so I'm going to jump to some problems with the potential of a social thesis. One of the problems is, I believe, that even if we accept that there is a social foundation to international law that goes beyond the strict confines of tests of validity as defined, for example, in Article 38 or a refined version thereof, there continues to be an insufficient attempt as to how legal officials come to be identified, how they become authorized. And if we're not careful about that, we can broaden the category to a point where anyone, as a matter of social practice, can self-identify and treat themselves as legal officials. And I could give you a couple of examples, including, for example, the authors of the San Remo Manual, or even the authors, and I was one of them, of the Tallinn Manual on Cyber Operations in International Law. By mimicking the procedures and vocabulary of authoritative actors, an authoritative claim is constructed and brought out into the world, basically eliciting and seeking out recognition from actors who matter, in particular states. Perhaps a quintessential actor in this respect would be the Red Cross, for those of you who do international humanitarian law. I think there is room in this argument, and there is room to consider whether, if we only point to social practices, we suggest that somehow anyone who uses the right vocabulary and techniques is accepted as an authoritative actor. And in that sense, time being what it is, I'd like to conclude a little bit with the implications of what this means for international law. And obviously, this is probably a bigger project than just an article. I think to excavate the notion of authority is well, sometimes quite daunting as a task. And so in this piece, I just want to set out sort of a few potential implications for accepting the claim that there might be some sort of social foundation rather than purely formal foundation for the development of international law. And I want to do so by talking a little bit about what I call the common discourse rules of international law, which I draw from a number of authors, in particular, the famous Fish-Fist debate on interpretation in American legal theory, but also it's something that's been picked up by others. To start, though, I do feel I need to point out that it can look somewhat bleak. The idea of like-minded elites, mostly international judges, legal practitioners, advisors to states, resolving legal disputes, all sharing a common language and grammar, rejecting all others who seek to disrupt that with claims of justice, with claims of based in ethics, ideology, or politics. This is not particularly encouraging, and it is a pessimistic view of Schachter's invisible college of international lawyers, to be sure. But at the same time, I'm not entirely sure that it is false, because I do think that there is, to a degree, a shared ethos which privileges systemic unity and coherence, as I've mentioned before, and if necessary, feels it useful to construct the existence of norms to resolve these normative conflicts, to maintain order and secure it through successful claims of authority. In order to get there, how do they do it? And again, this is a broadly theoretical exercise. I'm hoping, though, that those of you who are versed in the practice of international law understand this. But I think it's useful to point to the metaphor of a grammar. Pierre-Marie Dupuis has used it, Andrea Bianchi has used it, Daniel Piet has used it. But the notion that the technical proficiency to employ, to use, to redeploy concepts of international law is to master its language, to master its grammar or syntax in order to justify not only the validity, but also the determinacy of international legal rules. There was someone, his name's Dirk Pulkowski, whose monograph in 2014 studied the language being used to justify non-fragmentation. So his study was on self-contained regimes. In his book, he updated the notion of grammar and called it discourse rules, a grammar for communicative interaction. Although it's an imperfect metaphor, I think it allows us to situate how a specialized regime fits within the broader regimes of general international law, but also makes an appeal that all of us who speak at least one language, I'm presuming, how we make sense of international law, what counts as a valid argument, what doesn't. And nothing would illustrate this more to me than the experience that I've had as a competitor, then a coach, then a faculty advisor and a judge at the Jessup International Law MOOC competition. Almost 90% of the feedback we give, and for students in the audience, you'll probably recognize it, is to berate the students for making an argument that will not be acceptable. Part of that is to inculcate a sense of what counts as international law and what doesn't. And so I believe that the identification of these common discourse rules is particularly important, because not only is it about recognition of the discourse rules, but who gets to set them and who recognizes them as legitimate and authoritative. The reason that matters is because the actors with the power to do that both situate their authority within the international legal system, and they strengthen the coherence and order of the legal system itself. So thus, coherence is not an inherent property of law, but it's the logical consequence of its application by systemic officials. It's a result achieved. It is not a necessity for a legal system to exist. So who controls it? And this is where I'll end. Well, Stanley Fish popularized the term interpretative communities, a term not so much about a group of officials who share a point of view, but a point of view and a way of organizing experience to the point that it binds us together. The community is constituted not because people join it voluntarily, but because members find themselves embedded in the common enterprise of that community. I think there's something to be said there about the epistemic community, the practice community of international lawyers, who, while not necessarily committed to upholding the law, perhaps finding fault with certain points, wishing to reform the law from within, to change the law through accepted processes, nevertheless constrains itself by the notion that there is a faith in law, that there is a faith in understanding and mastering the law, and a faith in engaging with the law. In many respects, this was one of the existential debates that I had when I'm drafting my own textbook on the teaching of international law and how to do that. Was I merely inculcating rules that might be imperfect, problematic for political, ethical, or ideological reasons, or are we giving students access to the toolbox, the vocabulary necessary to understand and to be taken seriously as an international lawyer? But in so doing, are they internalizing the choices made in developing that law, the choices made in history, the choices made in response to events, the choices made in how we deal with crises? Look at the pandemic right now. Well, perhaps. But nevertheless, these common discourse rules are indispensable because they are the only way in many respects to claim a place within the interpretative community. So a student, a newcomer to international law, finds themselves best taken seriously when they are capable of demonstrating that they can adhere to the shared canons of the interpretive community. Technical proficiency defines membership, and it emerges as the hallmark of the international lawyer. I am speaking for too long. I could say more, and I could veer in a certain direction as to the consequences of this. But I think this might be the moment actually to be a bit restrained and to conclude by saying that if there is such a thing as an interpretative community of international lawyers, with shared common discourse rules that define and structure the manner in which we engage with law. And if our judges, our legal officials, our legal advisors to states, and legal practitioners all adhere to them, then something different is taking place than the arid act of clarification when legal norms are interpreted, especially by those said actors, those said systemic officials or even systemic agents. In the interpretative process, we go further than just clarifying the existence of norms. We reinforce the process of legal reasoning. We distinguish the act of interpretation as uncovering meaning and the act of interpretation as developing the law. If coherence is a systemic value of the law, then the law reproduces coherence and privileges it over possible other values. What those values might be are perhaps matter for personal conscience. Each of us will have a different sense of what they are. But I do think that the claim to authority is thus not normatively innocent, but it is a claim to control the development of international law itself. I think I'll stop here. Thank you so much for your time. I look forward to questions, whether in the chat or by turning on your microphones.
Wonderful. Thank you so much, Professor Hernandez, for such a brilliant lecture. So many different kind of things. I've been taking notes, and it relates to so many different things that I've been thinking about as well. But just a reminder to our audience, please do put your questions in the Q&A box. We have just over 10 minutes for questions. So we have a few kind of longer ones that have come through. And I actually wanted to start off with this first one because it relates in particular to what you were discussing at the end of your presentation around kind of mimicry and the mastery of language. So the person, it's an anonymous attendee, and they thank you for your fabulous lecture. And they ask, as a PhD student myself, I was wondering what your advice would be for a student working on critical approaches to international law. Is it possible to use the language of international law and transform it in your own aims? Or is that near impossible given the limited framing of international law that international lawyers end up inevitably promoting to be recognised? And what do you see as the best method for fostering a transformative politics using international law? So quite a few questions in that, but some advice asked.
Okay, shall I answer them in turn like this? Shall we do it as much as back and forth as possible? Well, thank you. And thank you for also kind of situating yourself and the sort of research that you do. I do think that it is possible to use the language to transform it to your own aims. I do want to question, though, why your aims are preferable to my aims or anyone else's aims for that matter. I'm serious here. We engage with law as a political project. And I think it's not unfair to say that even the mainstream orthodox formalist international lawyer probably does. Maybe it is a faith that law is objective, a faith that law can be neutral. But nevertheless, there is a choice that's made there. But if we engage with the law because we want to make it more feminist, more economically just, more climate friendly, all values which I politically agree with, I think there are two things that happen. One of them is you might lose the ability to make your argument effectively because the law itself does not reflect your values. And I'm not saying that something is necessarily lost there, but it is the risk that you take. So human rights activists, NGOs, climate change activists, I think they deal with this risk every day. Do we make a claim and lose it because the argument will be determined to be invalid? I think your question, though, goes rather to a question of conscience or a question of method. In using the toolbox, do we internalize the values of the law itself? And that is a really, really difficult answer. I think we can. I think sometimes we do. And I think it's important to continue to point that out. I think the vocation or the engagement, so I teach a legal theory class, and I'm always telling my students, whatever your choice, to practice the law, to judge the law, to apply the law, to think about the law, to do research about the law, that choice will also influence how you play with it. Yes, it might not be transformable to our own aims because the law doesn't lend itself to that. But by engaging, for example, in civil society and in advocacy, you are doing your damn best. By engaging in scholarship where you try to point out the injustices in the law, you perhaps open up the space for others to see that and to effect change within the law. Those would be, I think, useful for internal critique. And some of us just need to walk away and go write about philosophy, politics, economics, and all the other forces, all the other social forces that structure the law. And I think that's a perfectly valid choice as well. But I would distinguish in this respect between internal and external critique. I hope that's helpful.
No, that's very helpful. Thank you so much, Professor Hernandez. So I have a question that's come in from Christian van Eyck, who asks, what implications does this have on how we read large multilateral treaties? You've spoken about the way we read law now, but what about the law in its making? And continues, we know that certain states phrased legal arguments more within principle than the positivist language of international law. For example, Latin American states regularly noted this throughout the outer space treaty debates in the 1960s. If we now note a social mark of authority in international law, does this imply we should read treaties differently? Oh, you're on mute. Sorry.
My apologies. Even after a year and a half of Zoom, I forget to unmute myself. Christian, I think this is a very interesting point. And it's a specific point in the sense that you're asking me to take theory or the thoughts that I've got, which I would not call a theory, but rather a collection of observations. But how do we do this in practice? Isn't the point that it depends? If you are a judge and you've been elected by the General Assembly and the Security Council to sit in the Peace Palace, you are going to feel constrained by the weight of tradition, the way that your fellow judges will treat the way that you're interpreting. You will be faced with arguments by parties that are channeled in a specific form. But that is a completely different level of constraint than if you are advising an NGO or advising a group of victims who are seeking to access a domestic, regional, or international court to formulate a claim with the policy outcome in mind. I do not think that anything that I'm saying constrains any of those actors. What I'm saying is that I think it makes us all more aware that our situatedness makes it difficult to arrive at what is called an objective interpretation. Rather, that objective interpretation is the one that is most commonly accepted and recognized. And yes, we are all using language, we are all using legal texts. You cannot redefine an objeto de comercio. Sorry, I'm thinking about one of the cases, but one of the ICJ cases. Well, you cannot define a river as a giraffe. Okay, I get that. That is to exceed the bounds of linguistics. That is to exceed any sort of bound of shared meaning. But at the same time, there is room in concepts like effectiveness, breach, necessity, proportionality. Caroline Foster has written a really lovely book. It's very meticulous, very detailed, but she writes about the use of certain terms that she calls global regulatory standards, which are structurally indeterminate. They only become operative in a judicial or practical setting, and thus they open up a certain space for discretion. They open up the discretion for judicial authorities or for law applying authorities, but also a certain amount of discretion by the actors that are, how can I say, sorry, let me be really analytical about this, by the addressees of the obligation or of the standard. And I think that that suggests that indeterminacy is not a problem to be cured, but a feature of the law, and that feature of the law empowers certain actors. And I think in that sense, if I may, because I see that there's a question by Andre de Hoog, which is, and maybe I'll just read it out because it links to this. International lawyers are not bound by international law. International law does not address us. That is perhaps correct in our individual capacity. But if we want to be taken seriously as legal practitioners arguing international claims before international courts, we will internalize that language. If we are law students who want to get good jobs working for international law firms or international institutions, we will master and internalize that language. Without that language, we will be treated as irrelevant and pushed into the margins, which is a large critique, I think, of many of those who identify as critical legal scholars. And I think that's a critique that deserves to be taken seriously. We're absolutely not bound by international law. But no one would buy my textbook if I made all sorts of errors as defined by the international community as to, for example, what is a treaty, what is an obligation, what is a countermeasure, what is use of force, is it different from an armed attack, etc., etc. So no, we're not bound, but we will behave as though we are bound. And I guess that's what I'm trying to say.
Fantastic. Thank you so much, Professor Hernandez. And you came to the next question that I was going to ask you anyway. So I wanted to move on now to a question from Martins Paparinskis, who says, wonderfully rich as always. You provided examples of the actors and institutions that succeed in establishing authority, particularly the properly articulated arguments of state officials and international courts. Could you give any opposite examples where establishment of authority was unsuccessful, for example, by failure of mastery of the grammar of public international law?
That's interesting. Thank you. And I will refer to Martin Spice first thing, because he's my dear friend. We were students together. We have secrets. No, Martins, that's an excellent question. And if I may, I would answer it with just a couple of almost easy examples. Any entity aspiring towards statehood that tried to rest on a right to external self-determination or secessionary self-determination, or where the holding of a referendum generated a legal right to independence, or where the self-identification as an indigenous group or a minority group engendered, outside the colonial context, a right to self-determination. That would be one. Other examples might include those that have argued the legal personality of the environment or watercourse or shared natural resource. those that have argued that the precautionary principle is customary international law, or that all human rights are jus cogens. These are examples that have, I think, failed. You could argue they have failed because they are wrong, but you could also argue that they misunderstood others that would listen to that argument. And I think it's a different way of describing the phenomenon of claim, recognition, rejection, and the way that the dialogue and the discourse tend to proceed. So I would give those examples. Other examples, sorry, one last one, I can't help it. But those that argue that multinational corporations are bound by certain human rights norms. And the guiding principle sought to suggest that some of them are a codification of existing law, but in the main, much of it was articulated through the language of progressive development, and as such, kind of reconfirming the lack of binding force of many of those claims. I hope that's helpful. That was a bit long-winded, sorry.
No, I think that was really helpful. Thank you so much, Professor Hernandez. Yeah, I think it's a really interesting question. This there's another question coming in, probably our final one for the day, which I think relates to this quite a lot. So it's taking a little bit of a different perspective on this kind of debate that Dr. Paparizkis has brought in. So again, thank you for your lecture. This person says that they've been reading Dina Zuvala's Capitalism as Civilization, and she highlights the way that global South actors, via engaging in the language of international law and seeking to use it for radical aims, often end up not being heard and their arguments being watered down through their use of language of international law. So the question is, how does the language and structural bias of international law relate to your focus on international lawyers themselves? And the kind of main question that they get to is, after all, are these arguments being made? These are arguments being made by experts, but the logic is being manipulated. So the fault and limitation seems to be more the law itself and less these kind of experts making mistakes. So a little bit of an add-on to what Dr. Paparizkis was saying there. They're just asking what your thoughts are.
Well, thank you for that question. The world is very small. Dina Zuvala, Dr. Zuvala, was my first supervisee. She did a PhD at Durham when I was a young lecturer. We've dialogued for years, and I have great respect for her understanding, and it has shaped mine. I would say there's great weight in the argument that the language of law itself constrains, that it is not about the lack of mastery of grammar, and that if anything, those who are using the law in that way are marginalized. That may be the problem with international law itself. Dr. Zuvala tries to point out how that is done, how those that articulate emancipatory or broadly disruptive claims are, I wouldn't say so much discarded, but not taken seriously. And one of the points, in fact, that I'm trying to write about now, I have an essay. It's going to turn into a piece, probably at around the time that the second edition of the textbook publishes. But basically, a personal essay about my experience as an author of a textbook, understanding that indeed, in inculcating the law, in teaching the law according to one method, a determinate method, am I not, as a scholar, also participating in it? That is not to say, and here's the thing, it is not to say that there may not be a right and a wrong in the way that international law is argued. In fact, I do think that the social epistemic community of international lawyers does set those rules. It is to say that when you engage with those rules, you face that challenge every day. And if you don't keep asking yourself that question, then in some respects, some points then become internalized as a matter of your practice, as a matter of your method. Of course, this is an argument primarily directed towards scholars. And I know that this lecture series reaches beyond scholars and across the various vocations through which we engage with international law. I realize that, and I made the choice to structure this lecture accordingly. But I think for those of us that consider ourselves scholars of the law, there is room for the sort of scholarship that seeks to wonder whether there is that structural bias, but doesn't take it as a given, constantly asks and interrogates and re-asks, how is there structural bias? Why is there structural bias? How does it proceed? It's not enough for me to say there is, and then just to say, so we need a certain kind of politics to reform it. But that's my own personal choice as an international law academic and how I've been directing my research, if that makes sense.
It certainly does. Thank you so much, Professor Hernandez. And wish I could have sat in some of your supervisions with Dr. Zuvala, of course, would have been amazing. And the reflective piece sounds wonderful. We'll all be very much looking forward to that, your own reflections on writing the book, of course. But we are unfortunately out of time, and we had a few more questions, but we can't possibly get through them. So apologies to those people. But I just want to say a big thank you so much for joining us for a really fascinating lecture. Yeah, thank you so much. Dr. Wong, did you want to say something?
Yes, I just wanted to echo Dr. Jones in expressing my gratitude to Professor Hernandez for speaking and sharing his research with us. It is really such, it is so great to have you. And also this brings us to our last lecture for this term. So join us next term where our opening lecture will be by Professor Sean Murphy. Something to look forward to.
Thank you for having me. Have a wonderful evening and healthy festive season, everyone.
You too. Thank you very much. Bye.